Hi, welcome to Criminal Law TV, where I discuss generally things that go on in Virginia criminal law and around the world, around the nation. So this week we're going to talk about Virginia's new laws.
The number you have reached, 911, has been changed to a non-published number.
Okay, hi, I'm Ken Lammers. This is Criminal Law TV. For those of you who've never seen this before, this week we're going to talk about the new laws in Virginia that went into place on the 1st of July 2013. I know I'm a little bit late getting them to you, but I've been around, briefing police departments on these changes, sheriff's departments on these changes, some local bars, and that sort of thing, legal bars, dirty minds. Now, we're going to start today with procedure, and tomorrow we'll get into actual crimes. So, the first thing we're going to talk about is, they're kind of in a mixed order of procedure. It's kind of a catch-all for everything else. But the first thing we're going to talk about is appealing contempt. Virginia has passed a law, the General Assembly has passed a law, 18.2-459, saying that an appeal of a contempt from General District Court shall be a bench trial, tried by the judge. Now, the maximum sentence you can get on a contempt from General District Court is 10 days in jail, which means there's no federal constitutional issues with this. However, the Virginia Constitution does require anybody who is, or does require that anyone who has a criminal charge has an absolute right to a trial by jury of people in their vicinage, county or city, basically. And there's no exceptions there. And this is a statute, 18.2-456 being the general contempt statute, and 18.2-459 being this statute. They're in the criminal law section, and therefore it would seem that this is violative of Virginia's Constitution. However, we'll see how that plays out in reality. Magistrate supervision. Now, as we all know, over the last few years, magistrate supervision has been taken away from local, where the chief judge of the General District Court had control, and aggregated to Richmond. There's not a whole lot of people in the local bars and local judiciary that are incredibly thrilled by this, but it's there, and we have to deal with it the way it is. Well, there was one last little bit that was still, being supervised by the chief judge of the General District Court, and that was TDOs, temporary detention orders, the orders to take someone to a mental institute so that they can be checked to see if they're okay. That was finally changed over to Richmond as well this year. So now I don't think there's anything that the General District Court judge controls or supervises the magistrates for anymore. Certification of court documents, under 8.01-389D and E, copy teste, true copy, certified copy, or any kind of similar writing, stamp, etc. by the clerk means it's a self-authenticating document when it's introduced in court. So, I don't know what the problem was there, but it is what it is. You can introduce them in court with those things. For the appellate courts, 19.2-324.1, if evidence is erroneously admitted at trial, the court will do a totality of the circumstances analysis and a harmless error analysis to see whether or not the case should be remanded or reversed. I thought this was what they were doing already, except in certain constitutional cases where they're not allowed to. But apparently the General Assembly felt it had to be written into the law somehow, other than just case law. Delinquencies at school, 22.1-279.3:1, parentheses D. A principal at school has always had to report certain things that go on. Among them, the list is things that would be a felony if done by an adult: sexual batteries, conduct involving drugs and alcohol, threats against school personnel, illegally having a gun on school property, having explosives or threatening to blow something up. Those sort of things had to be reported to law enforcement officials. Now, however, the statute has changed so that if they're reported, there is no requirement that there must be a petition for delinquency filed. The statute is not very helpful as to who's going to make that decision. It says that this can be handled in school. Statute isn't very helpful as to who's to make that call. The bill or language in the bill had some nice words of how some agencies in Richmond were going to come up with a model agreement that would be used by law enforcement and school officials. But that's not the law, and I think really this is going to have to be a call by local law enforcement official when told of these offenses. Unmanned drones. For those of you who are worried that Virginia is going to have unmanned drones flying over your head all the time, watching what you do, fear not. Virginia's General Assembly has said that until July 1, 2015, the Virginia law enforcement cannot do such a thing. They can only use unmanned drones for Amber Alerts, Senior Alerts, Blue Alerts, and search and rescue operations, or training for one of those. I personally don't know any law enforcement that has a good, solid drone that can fly for several hours above your head. Maybe some of them do out in the bigger cities, but you don't have to worry about that anymore. Virginia's law enforcement cannot do such a thing. Of course, that doesn't stop the feds, but there's only so much the General Assembly can do. 19.2-124C and 19.2-132 allow that if a bond is revoked, increased, or lessened, that the court that does so can stay the change until a higher court has an expedited appeal. Except there is one exception under 124C. If the defendant is already released on bond. So there you go on bond changes. Now, furthermore, on bonds, the judicial officer setting a bond or allowing a person to have a bond, usually the magistrate, can order that the person getting a bond has his picture and fingerprints taken. I kind of thought this was taking place already, usually before they went to the magistrate. But in case it's not, they can order it, and that's under 19.2-123 paragraph or parentheses A parentheses 3C, and under 19.2-390, the fingerprinting and photographing can be done where the magistrate is. The person doesn't have to be taken all the way to the jail to have that done, which I'm sure both that person and the law enforcement officer involved are happy about. Escorting prisoners out of state for medical treatment. This has been an issue. This is an issue on the borders. Now, those of you that are solidly within Virginia, or you're in a built-up area in Virginia, even if it's near the border, probably don't have this problem as much. But for instance, here we are one county over from Tennessee, 2 counties over, I believe, from West Virginia, and we border Kentucky. People who are in jail are constantly asking for furloughs so that they can go to Kentucky or Tennessee to get medical treatment, because they always swear they can't find a doctor in Virginia who can do it. So the General Assembly has passed a statute, 53.1-133.10, allowing law enforcement to escort these individuals to the other state, guard them while they're getting treatment, and escort them back. So, of course, this requires that the other states have passed the same law, a compact. It doesn't address things like who will prosecute if there's an escape or an attempted escape during this time. If they go to Tennessee or Kentucky, will that state have to prosecute the escape, or will it actually be brought back to Virginia? Uncertain about that, but and I've not been able to find the same laws passed in Tennessee or Kentucky. If anybody has seen such a law, please let me know about it, because I really need to know this thing. Okay, next thing. Under 19.2-72 and 76, a jailer can now execute warrants, summonses, or capiases to bring someone to court, which is good. That means a deputy doesn't have to travel 6 counties over 2 hours, to execute something on somebody who's in a regional jail somewhere. It can be done by the local jailer, and which should be a lot more convenient for everybody, I guess, except the local jailer. Mandatory minimums. For those of you who don't know, there were a pair of cases out of the Court of Appeals and the Supreme Court of Virginia last year in which they said that mandatory minimums could run at the same time as punishments for other offenses, could run concurrently as punishments for other offenses, unless the statute specifically said they could not. Now, for those of you who are not from Virginia or who don't understand the lingo, mandatory minimum are sentences which cannot be suspended by anyone. The judge, the Supreme Court, nobody can suspend a mandatory minimum sentence. So therefore, for instance, on a felon in possession of a firearm, 2 years in prison, and nobody can suspend it. So now, when the Court of Appeals said that these things could run concurrent with other offenses, the General Assembly and the Supreme Court said the same thing. The General Assembly went in to revamp the law. The House of Delegates tried to pass a statute that said all things that had mandatory minimums would run consecutive to other punishments. But the Senate put forth its own bill in which it listed specific offenses that would run consecutive. And the Senate's bill is the one that actually passed. There's no actual statute for this. They added on to all these statutes. But the Senate has said, this bill says, violating protective order, if it has mandatory minimums, you will serve mandatory minimum consecutive. Same for rape, forcible sodomy, object sexual penetration, gang activities, shooting at a vehicle, purchasing a firearm for an ineligible person, or producing child pornography. Any one of those offenses, if someone's convicted, their punishment must run consecutive to the other offenses, punishments. That does leave open certain things like felon in possession of a firearm can run concurrent, or using a firearm in a felony could run concurrent, or DUIs, where there's specific punishments, mandatory minimum punishments, which cannot run concurrent with each other, with other punishments underneath the mandatory minimums underneath the DUI statute, but can run concurrent with other punishments, say for driving suspended or something like that. So things to keep in mind. Violent offenses. Now these really, they've added to 17.1-805C lists all the violent offenses in Virginia for certain purposes. There's another list of violent offenses for the 3 strikes statute, but these are for basically violent offenses as they are dealt with in other areas, including where they'll probably have the heaviest effect is the sentencing guidelines. So the violent offenses, the things that have been added to the violent offenses this year are any felony violation of a protective order, killing a fetus, threatening or using force or violence against family members or a person for gang purposes. Strangulation. You'll recall this is a new law that was put on the books last year. Now they've made it a violent crime. Assault and battery based on race, religion, or ethnicity. Felony violation of 18.2-60.4. It's another violate protective order. Violation, having sex with somebody with the intent to transmit HIV, hepatitis B, or syphilis. Using a fake or real firebomb. Discharging a firearm in a public place. Committing armed felony, wearing body armor. Grooming individuals, displaying grooming individuals to a minor. What this means is showing them materials, sexual materials or semi-sexual materials, in an attempt to get the minor comfortable with the idea of having sex with the person who's in the majority. burning a cross with intent to intimidate, placing a swastika with intent to intimidate, displaying a noose with intent to intimidate, treason against the Commonwealth. Never seen anybody charged with that yet. I'm still waiting to see that. Escape when committed, and disseminating information gathered at the Virginia Fusion Intelligence Center. So all those will lead to extra punishment to individuals in the future. Multi-jurisdictional grand juries. Primarily when you run into multi-jurisdictional grand juries, they have to do with drug offenses. However, the General Assembly keeps expanding this to what other things that multi-jurisdictional grand juries can investigate. Probably so that they can expand on the drug offenses that are being investigated, but some of them I think are just because it sounds good to be able to investigate them with a multi-jurisdictional grand jury. Now, what they've added this year under 19.2-215.1 are mob offenses. Now, this doesn't mean your mafioso, don, whatever offenses. This is basically your old Klan offenses, group offenses. Assault and battery by group, lynching by group, that sort of thing. Felonious assault, that includes malicious wounding and malicious bodily injury, strangulation, felonious sexual assault, arson, RICO, forcing someone into prostitution or pornography, and investigating money laundering. Like I say, a fair portion of those have to do with drugs. Others are things you might trip across during drug investigations. Some of them, I'm not sure why a multi-jurisdictional grand jury would be investigating strangulation. It could be something that comes as just a collateral issue that popped up, but I don't know that there would be a pattern of strangulation across a multi-jurisdiction. Anyway, be that as it may, that's it for the procedural stuff, folks. Tomorrow I'll start up with the actual substantive crimes, and we'll try to get this done by Friday. Y'all have a good day now.